Good morning. Thank you, Carol. I do, for that nice introduction, I do want to make one clarification when you were talking about Bob and I being heads of agencies and being involved in indigent defense on opposite coasts. You used the term decades, and just to correct that, it's a little lower for me, only a couple of decades. So,
Hey, plural is plural.
So I'm here to talk to you a little bit about the different end of the spectrum from what Professor Singer was talking about in Louisiana, and that's the Massachusetts system. It's a state agency, the Committee for Public Counsel Services. Tell you a little bit about our experience here in Massachusetts, and then talk a little bit about two specific challenges to Gideon that we have faced over the last 20 or so years. Massachusetts system is a statewide 100% state-funded system. It's one of the only statewide systems in the nation. It was established back in 1983, and it's a predominantly mixed system. What that means is we have approximately 800 employees, approximately 500 of whom who are case-carrying attorneys, and that includes attorneys in charge, supervising attorneys, so 500 or so attorneys who carry some level of caseload. And most of the cases are handled by private attorneys. And what I mean by a mixed system is 25% of the cases in the state are handled by staff attorneys, and 75% of the cases are handled by private assigned counsel. And the 25% are handled by state salaried public defenders, and the 75% of the cases are handled by private attorneys, and those are attorneys who are paid on an hourly basis, on a per case basis. And the agency is overseen by a 15-member independent committee, and the committee is made up of 9 members who are appointed by the Supreme Judicial Court, one of whom is Carol Steiker, 2 of whom who are appointed by the governor, 2 appointed by the Senate President, and 2 appointed by the Speaker of the House of Representatives. Now, the agency has a very wide range of responsibilities and provides counsel to indigent persons in a number of areas. And it's essentially broken down into 4 specific divisions. The first is, of course, adult criminal representation, and within the agency that's broken down into 2 separate and distinct sections, one that oversees the public defender staff and one that oversees the criminal attorneys on the private counsel side. We provide representation to juveniles and delinquency case. We have a juvenile, fully staffed juvenile division. We provide representation in a number of mental health cases. And finally, we represent individuals and children in family law cases, and that includes termination of parental rights and children in need of services. In fact, actually, there was a change in the law last year. That's now called FACES, Family and Children Receiving Services. So we have a wide range of responsibilities. And in addition to that, we provide representation in a number of other administrative type proceedings. So we're lucky enough to be able to do a number of things for individuals in Massachusetts. We also provide representation in probation revocation hearings, juvenile revocation hearings. Massachusetts juveniles have a right to jury trial. We provide representation in juvenile jury trials. And we also have to do some grant-funded work where we work with the local educational law center, and we work with them and provide educational representation when there is a child who's involved in a criminal case and there's a situation that's going on in the school. We're able to provide representation. So we have quite a wide range of responsibilities in Massachusetts. Now, Massachusetts has been recognized nationally by a number of individuals as a model program around the country and a model for other states. We've been recognized nationally by Dean Norm Lefstein, who is the dean at Indiana University Law School. He has commented on Massachusetts being the only statewide public defender that follows the ABA 10 principles of public defense. We've been recognized by the Department of Justice and the National Legal Aid and Defender Association. So why has Massachusetts been recognized as a model program? Well, first and foremost is the training. We provide extensive training to both staff defenders and members of the private bar. Staff defenders engage in a 5-week training program in their first year. And members of the private bar are required to participate in a certification training before they can participate on a panel. And we also require continuing legal education as they continue their time with CPCS representing indigent clients. In addition, if you're a member of the private bar, you need to be certified. You need to apply and be accepted by CPCS in order to take cases. And if you are interested in taking, representing people in more serious cases, felony cases in superior court, or representing individuals in murder cases, you need to apply, you need to show that you have the experience, and they'll look at the work that you've done at the lower level before they accept you to participate on one of those panels. We provide supervision and mentoring on both the public staff side and the private side. We require recertification for members of the private bar, and what that means is after 5 years, we have staff who will look at a private attorney's work to determine how well have they been doing. Have they been filing appropriate motions? Have they been engaging in the appropriate client contact? So that's something that we've engaged in, especially within the last 2 to 3 years, and that is something we think it goes a long way towards improving our already tight private counsel program. But I think the two main reasons we have been recognized as a national program are the caseloads and the oversight. And getting back to the oversight, we have performance standards, both for the staff and the private bar. And from what we know, we are the only state where not only do we have performance guidelines, but we have oversight to ensure that attorneys are doing what they're supposed to be doing. The only other program or jurisdiction that we're aware of that does that is one of the county programs in California, San Mateo County, which is a predominantly private counsel assigned program. And the other main reason are caseloads. We have very strict caseload standards for both the public staff attorneys and the private bar counsel. And we recognize that it's not just caseloads that are important, but workload. And in that spirit, we recognize that although we have caseload standards, they are not inflexible numbers. What needs to be looked at and what we look at are what types of cases are the attorneys handling? What's the experience level of the attorney who are handling the cases? What types of cases are they handling in terms of the makeup of the numbers of cases that they're handling? We also look at geography. Where are the attorney practicing? In Massachusetts, as I imagine in most other places, where you practice makes a difference. There's a difference between counties, there's a difference between policies of district attorneys and practices within individual courts. And in many instances, the practices differ even within a specific county. And for those of you who are familiar with Massachusetts, there apparently is a very big difference between some of the different urban courts in terms of the practices of the district attorneys and the practices of the judges in that court. So those types of things are taken into consideration when we're looking at what is the workload of an attorney and what are they able to do, and do they have the time to do all the things that are necessary in order to provide appropriate quality, high quality representation for our clients. Now, some of the challenges that Massachusetts has faced over the last 20 years, and the first major challenge that I want to talk about took place back in the early 2000s, 2002, 2003. Now, although Massachusetts, even at that time, was recognized as a model program, one of the big problems we had was the hourly rate that was paid to private attorneys. Private attorneys at that time were being paid $30 for district court cases and lower level children and family law cases, $39 for superior court case felonies and termination of parental right cases, and $54 an hour for murder cases. So I think I don't have to tell you that is woefully inadequate, and attorneys in the early 2000s decided to do something about it. In 2002 in Western Mass, there was an attorney shortage in children and family law cases. There weren't enough attorneys to take cases. And it really bubbled up in 2004, again in Western Mass, when there were not enough criminal attorneys to take cases in Hampden County. And what that led to was a number of defendants going without representation and being held in court without seeing an attorney. And what the court tried to do, what the trial court tried to do, was force the staff offices in the agency to have their public defenders go over and pick up these cases and represent these individuals. Well, the problem with that was they were already at their caseload limits, so they couldn't take the cases. And so what CPCS did was bring litigation along with the Massachusetts American Civil Liberties Union and some of our other allies like the Massachusetts Bar Association, the Boston Bar Association, and on behalf of these individuals alleging that their constitutional right to counsel had been violated. And so, as you can see, this was a major challenge to what CPCS was all about, a major challenge to our caseload limits, a major challenge to our independence. And in a major groundbreaking decision in July 2004, Lavallee versus the Justices of Hampden County, the court affirmed CPCS's ability to set caseloads and found that these individuals, the defendants' rights had been violated. Their right to counsel had been violated under the Massachusetts Declaration of Rights. And in doing so, they acted decisively in safeguarding our caseload limits and in affirming our independence. So that was a major victory for the indigent clients of Massachusetts. Now, what was the result of that Lavallee decision? Well, the legislature acted quickly and immediately raised the hourly rates by $7.50 an hour and set up a legislative commission composed of not only legislators but a number of professionals from the legal community to study the indigent defense system in Massachusetts. And they made a number of recommendations, many of which the legislature adopted, and the legislature, to their credit, reacted quickly again and raised the hourly rates to the point where they are now, which is $50 an hour for district court, still inadequate, but clearly a big difference from where they had been. $50 an hour for district court, $60 an hour for superior court, and $100 an hour for murder cases. The legislature also adopted a recommendation by the commission to increase staffing levels. And so they gave us the funding to hire 110 new public defenders, 20 new attorneys in the children and family law and delinquency area. And the 110 lawyers that we were told to hire were for district court representation. Prior to that time, CPCS predominantly represented individuals in superior court felony cases, bind over felonies and felonies. And so our ability to hire 110 new attorneys across the state, we were able to put offices in every county and have attorneys beginning to represent individuals in misdemeanor cases in the district courts across the Commonwealth. So that was quite a great accomplishment in terms of improving the quality of representation on the district court level. The other recommendation that the commission adopted, recommended that the legislature didn't do much about at that time was they recommended decriminalizing a number of low-level misdemeanor offenses. And that's important, and you're going to hear a lot more about the problem with misdemeanors, is that much of our budget, as in many places, is driven by the number of cases in the system. And in Massachusetts, there are a huge number of misdemeanors where we represent clients, and the overwhelming majority of whom never go to jail, as all of you know. And so the legislature has, in the last few years, made some minor steps in that direction, and there has been some decriminalization in some areas, mainly trespassing and minor automobile offenses. So moving to the second major challenge to the promise of Gideon that CPCS faced, brings us to a few years ago in 2011, when the governor of Massachusetts proposed a radical restructuring of the mixed delivery system model. And what the proposal was entailed wiping out the private bar involvement in the system and wanting CPCS to hire 1,000 additional lawyers and the only cases that the private bar would be involved in would be conflict cases. And so completely ignoring the ABA recommendation that a model system be a mixed system and that a system have a vibrant, active private bar. And the other major proposal that the governor made was to wipe out the independence of the CPCS board and move it within the executive branch. So both of these proposals severely threatened CPCS's independence and severely threatened the quality of the representation that the agency provided. Now, the legislature did make some changes to the structure, but for the most part rejected much of what the governor proposed. And so where we are now is what the legislature proposed is a 25%, 75% mix. 25% of the cases handled by the staff, 75% of the cases handled by the private bar. Previously, it had been a 10%, 90% split. So 10% of the cases handled by staff. And so that's been a little over 2 years. And where, in terms of the status of where we are now, we have hired hundreds of attorneys, hundreds of other administrative support, professional support, to the point where we're pretty close to achieving that 25% goal. And some of you might be saying, well, how did you hire hundreds of people in 2 years? I still ask myself the same question, how we were able to do that, because it's when you're thinking hundreds of people, you're talking office space, you're talking going through the hiring process, you're talking about giving them all the tools they need to do their job, you're talking training. So it has been quite an undertaking, and it really is a tribute to the staff at CPCS who've been plugging through this very difficult process. The other change that the legislature adopted is they rejected the governor's proposal that the agency be moved within the executive branch, but they did make a change to the structure of the committee. Previously, all 15 members of the board were appointed by the Supreme Judicial Court. And as I said earlier, now there are 9 appointees by the Supreme Judicial Court, 2 by the governor, 2 by the Senate President, and 2 by the Speaker of the House. In the last 2 years, there have been 2 more proposals that we've been able to fight back. The next year, the governor came back and pushed further and tried to get the legislature to pass a 50-50 plan. So in the first year, we're in the middle of trying to put into place a 25%, 75% plan, and the governor came back and wanted us to push further and go 50-50. The legislature rejected it. And then last year, there was, during the legislative budget process, a proposal for a flat fee contract system, a pilot program in one of the counties where it would be put out to bid and attorneys could submit their proposal for handling a certain number of cases for a certain flat fee. Both of these would severely impede the quality of representation in Massachusetts, and luckily the legislature did not adopt either one of those. So in terms of where we are with the expansion plan, as I said, we have staffed up, and we have approximately 500 attorneys who take cases around the state, and we have gone from 13 offices to 28 offices around the state. Now, just a couple of final comments. As the ABA has said, and as Professor Norm Lefstein and others have said, a mixed system is truly the best system, where you have a mix of staff attorneys, dedicated staff attorneys, and a dedicated private bar who are able to handle whatever the caseload happens to be in whatever jurisdiction the program exists. But it really comes down, in my opinion, to 2 critical factors. And I know Professor Singer talked about, it's not necessarily money, it's the people, and he's right. And he talked about when you have a good system in place, it is about money. And caseload and quality control, because good lawyering costs money. And there is, when you are a defendant who is charged with a crime and facing the loss of liberty, you do not care whether you have a staff attorney, you do not care whether you have a private attorney. All you care is that your attorney has the resources and the time to spend on your case to make sure that everything that needs to be done gets done in the case. And there's a real disconnect between what has been going on in the criminal justice system and the funding necessary for indigent defense. And as I said, one of the factors that drives the cases in Massachusetts are misdemeanors. And the other big issue, as all of you know, is there's always a push for tougher crimes, tougher penalties. But most of the time, there's not that same push to, well, let's fund the agencies that need to do the work to deal with these additional crimes and these additional tougher sentences. So that's it, and I'll turn it over to Bob to talk to you a little bit more about the misdemeanor issue.